How you doing, everybody? It's July 8th, 2025. We're here for the coaching call, weekly coaching call, and I am going to be talking about today. Every week I talk about a different kind of topic, and today I'm talking about love letters. We're talking about those little love letters you write when you submit your offer to the seller, talking about how nice your family is, how they really enjoyed the backyard and they really want to be there because their grandmother grew up down the street, whatever it is. And it's interesting in 2021, Oregon, I'm talking about Oregon right now, and I know we got a couple people from California and a lot of people listening to this. Wherever you are, it's going to vary by state considerably. But in Oregon in 2021, they outlawed the love letter. They actually struck down law and said the love letters are discriminatory. And the reason is because if you supply a love letter with a picture of your family and your family's white, green, brown, black, whatever it is, they can make a racial discrimination choice on you accepting that offer or not, potentially. It's based on sex, religion, all kinds of things when you look in the discriminatory behavior of what the love letter may open up. And so what's interesting is a year later, it was challenged as part of being your First Amendment right. Your First Amendment right says you can provide these things. So then it put Oregon kind of in the crosshairs of what are we going to do? So actually, a district judge upheld it that they cannot say they're banning love letters. They just said they could not. It's against their First Amendment rights. The buyer has a right to do so. So then it was on the brokers to decide if we're going to allow it. So many listing agents were told by their brokers or decided that they were not going to forward love letters and pictures and all these things that are outside the contractual documents of a transaction, the offer, addendums, counteroffers, whatever it may be. And so basically it became on the shoulders of the selling agent to be the marshal, to be the police, to be the judge and jury of this. And that's always a really funky place to be in, right? So you had the law that says it was illegal to put in a love letter. You had the district courts that overruled that, saying they cannot do that. So the way Oregon did it, and every state's a little different, like I said, but what Oregon did that's really interesting, and I just recorded a video on this, which is why it's top of mind to me, is Oregon said, okay, it's still illegal, but we're just not going to enforce it. So that's literally where the law is in Oregon, as we state. The law is on the books. It's illegal. They voted on it to have love letters be involved in the transaction. They said it's discriminatory. The higher courts ruled that it's not, it's a First Amendment right. So now it's actually a law in the books that they openly say we will not enforce. So it gets back to the agent, right? It gets back to the buyer's agent putting in that love letter for the benefit of their clients. I think it's in their best behavior and best um, procedure to put in that love letter if it helps them, especially if the buyers are requesting it. It's up to the seller's agent now to distribute that to the seller or not. Like in my case, the way I read this law is it's like, it's why should it be up to the agent to decide to try and interpret that law, right? So for me, that was a challenging one. And so when I look at this from that perspective, I let the sellers decide. Mr. and Miss Seller, I got a letter from the buyers. It's up to you if I give it to you or not. It's not related to money. It's related to an emotional plea for the house, and we have multiple offers, whatever it may be, and let them decide if they want to see it or not. Um, but again, it opens up another can of worms opportunity wise, right? So, in my belief, I think the love letter, this is my belief, the love letter should be left out of the transaction. I think that it many times it can serve a purpose, but it depends on who you're serving. If you're on the buyer side of the transaction, then you obviously want to follow the wishes and requirements of your fiduciary responsibility to your buyer. If I'm on the selling side, I have an obligation to let them know potentially I received something, unless my broker said it's unallowed and it's in writing, it's unallowed. We're just not going to provide that to the sellers. That is the right of the and the responsibility of the listing brokerage. So you can see why this is such a strong thing for me because it's like there's no gray area, there's no right or wrong. It's a complete gray area. And when we get into you put in California listing agreement, seller must elect in writing whether or not letters will be available. Exactly. So you're preloading the decision on the seller on the listing agreement. Right now, it's part of that contractual requirement to decide if you're going to deliver them or not. And I think that's a great way to go. When you always lead with transparency with your fiduciary responsibility and document it and record it, you're going to be better off, right? So now the question comes up, what about if you have the listing, a buyer submits a love letter with a picture of a beautiful family, and your broker said not to give that to the seller, right? If you don't have something between yourself and the seller saying how that will be delivered, then you could be in harm's way. And for me, this is the challenge with real estate right now in this space. There's so much going on for not only disclosures. So the way I was taught and the way I was brought up, and I think it's the right way to go, is if you ever question if you should be disclosing something, then you disclose it, right? If there's ever a piece of a fragment of a belief in your mind that should I disclose this or not, if you use the word should I, would I think I should, then it's a 100% disclosure issue, right? Unless you're harming your client's position, which there are times you can harm their position, it's not your responsibility to disclose. But man, that's such a gray area that we're talking about here. Always reach out to your broker and ask them the question. Ultimately, the responsibility and liability rests with the brokerage, not the agent, right? The difference between an agent and brokerage, an agent has to work for a broker. A broker is responsible to the state requirements of all the agents below them. So typically, you could have multiple brokers, but for this conversation, you have a broker of record, and all the agents are sub agents of that broker of record. The agent is not a direct relationship with the state of California necessarily. The relationships through the broker of record or the broker, principal broker in that relationship, right? So if we relate this away from, because that could be confusing for some, if we relate this to the stock market, you have to be a broker to trade stocks in the stock market, but you can be an agent of a broker and work through that brokerage through a fiduciary and employee responsibility or something to trade on the market through that broker. So basically, the broker's got a registered number. You have to use the broker's registered number. If you don't have a broker's registered number, you can't trade on the market, right? So everybody has to trade through a registered broker on the stock market. Real estate's very similar. You have the broker responsibility is with the principal broker. All the agents, whether it's 90,000 agents like with EXP, although that's actually per state, right? So we have a state requirement that there's a broker, and we're so big, we have, I think, 4 brokers in California now, for instance. We have 3 brokers in Oregon, but there still is only one principal broker for the whole state. And so that principal broker is ultimately responsible for the other principal brokers, the agents, everybody that's under their license to do transactions in that particular municipality or state. So it's really interesting when you start breaking this down. And this is why brokers, as just a general rule, their first and foremost activity is liability exposure. It's protecting so the cats don't run around and get themselves into legal trouble or hot water, because whatever the agents are doing, the responsible party is the principal broker. All right. So hopefully that makes sense. But now in Oregon, what we've got is we literally have um, this love letter thing that was deemed unconstitutional by a federal judge and is no longer in effect. Means the real estate agents can once again share buyer letters with sellers. The ban was initially implemented to prevent potential discrimination based on protected characteristics, but it was ultimately found to infringe upon the free speech, aka the very first part of our Constitution, right? And so it's really interesting to me that people really don't understand this yet. And so when you put in offers and if you do enough transactions, you will get a mixed bag of nuts with this. You'll get many agents saying they're still illegal. You'll get many agents saying we don't do that. You'll get many agents saying you can provide anything you want, but I don't have a responsibility to provide it to my sellers. All these things are what's going on in the world. So again, Oregon's not that much different than most of the other states in the union. It just happens to be where I'm licensed and where I'm specifically engaged in making sure that my agents here are protected under both civil rights as well as the letter of the law. Pretty incredible stuff, right? I love this stuff because contractually, when you look at the contractual components of real estate, the one with the most knowledge typically is the boss. They're winning the contractual and negotiating race because they understand the contract better. Whether it's beneficial timelines, whether it's the removal of aspects of the transaction that's going to benefit your client. In California, it used to be a passive removal when I got into real estate. It was a passive removal of inspection periods and timelines. Example of that is if the contract said inspection period be 14 days, on the 14th day at 5 p.m., if the contract was written at 5 p.m., your inspections were done, right? You had no more inspection contingency period. That time elapsed. And so that's considered a passive removal of a contingency period. California got away from that. They made it where you have to physically remove a contingency even though the time is expired. So in that situation, if I said you have a 10-day inspection period, on the 10th day, I would say, for instance, Kenny, the inspections are up 5 o'clock today. I need that removal of that contingency. So he's been notified, but it's still not removed. It has to be removed by all parties, right? So he has to physically have his buyer sign to have that contingency removed, or it stays in place. If it stays in place past our timeline, then the next thing for me to do is issue a notice to perform, right? An NTP notice to perform means that I'm saying, Kenny, I've warned you, you've got to remove this by today. I'm giving you 24 hours to remove it, or we're canceling the contract. It does not remove in 24 hours. That contingency stays alive until they physically remove it. That is a very significant change in the contractual law of how this worked, right? I see many agents even today writing in inspections to be automatically removed in 10 days. Well, is that legal? Think about that for a minute and let me know what you think. Is that legal to supersede the California contract and write down that the inspections will be passively or automatically removed in 10 days at 5 p.m.? Is that a legal way to do it? Kenny.
Even though it is in the contract, I would say no, because the period of time has to materialize, has to go through, and you still have to release them. Because if it's in the original contract can be changed with an addendum.
I love it. So let's see if you're right or wrong, right?
That's it.
We're back to this gray area, in my opinion. In my opinion, IMO, just me, right? Randy Byrd talking about this. But let's say we write an offer and I say I'm going to remove all contingencies now. Is that legal?
Yes, you can have
Okay,
a CR. Oh,
right? So I can make it where there are no contingencies, even though the contractual agreement states that you have a 10-day or 14-day or a blank number of days for this inspection period. And it says in there that it's meant to be that way. You're supposed to remove that contingency after that period of time, right? So if you put it for, let's just exaggerate, let's put it for, you have a 1 minute timeline for your inspections. In 1 minute, I'm going to say, I want that removed. If you don't remove it, I have to give you a notice to perform to remove it. But I can negotiate up front that it's not in the contract, that it's been removed prior to the offer, which is very common in this multiple offer situation. So if that's the case, why wouldn't we be able to negotiate and say that in 10 days at noon, it's off? If you forget, you don't do it, it's your problem. It's off, right? In my opinion, that can be done. In my opinion, it's a mutually agreed term that you could write in the contracts. The contracts are designed to protect and preserve the buyer's rights, right? That's the number one, in my opinion, I'm gonna say this a lot because this can be argued, and I'm not an attorney, but my hundreds and hundreds and hundreds of transactions and teaching contracts and all the things over the years, what I believe firmly in is if it's a mutually agreed um, subject, then you could mutually agree on almost anything, right? You can't go against federal law, you can't go against discrimination, you can't do any of those things that are governed by law. but it's mutually agreed it could be done. If you say the couch is going to stay and both parties sign it, and then the person takes the couch, even though it's personal property, they have a legal right to pursue remedies and damages for that couch being there because we negotiated it, right? Or if you don't talk about it in the contract, then it's personal property. And that's when we get these gray areas with the cabinet was bolted to the wall. That means it's physical to the property if it's bolted to the wall, right? So, in my opinion, you can negotiate these things, and we have, right or wrong. I haven't taken it all the way to a trial attorney to figure it out. But in my opinion, if both parties agree to something, then it is, in fact, a negotiable instrument of the contract, right? And if it wasn't, if the state said you have to have a mandatory 5-day inspection period and it's mandatory, that's different, right? That's a mandatory guideline, but there is not a mandatory timeline for inspections per se. So again, the one that understands the contracts the most, and like if you wanted to be just the boss in this area, you would go to a really nice attorney, talk about the scope and the spirit of what the contract's doing, talk about what you want to accomplish, talk about why and the motivation behind it, who's benefiting, who's getting um, maybe the short end of the stick in this regard, right? Because it'd be the buyer, in my opinion, that would have that passively removed at a certain timeline. Can you write in there the buyer to increase deposit by $5,000 by Tuesday, the 23rd at noon? Absolutely. Right. So, again, in my opinion, everything in the contract is negotiable. Everything. There's not a piece of it's not negotiable. If all parties agree, you could literally say, I just don't like writing contracts on white paper. I want them on yellow notepad paper, and everybody agrees that it has to be on yellow notepad paper, then that the contract says it all has to be on yellow notepad paper, right? So it's interesting. I love contractual law. I love um, really understanding the contract at the highest level. I do not now. I've been out of production for years. I don't understand it. California contracts, one of the most cumbersome contracts in the state and nation. What is it now? 44, 46 pages without the addendums and stuff. I don't know. I don't remember the exact number.
27.
27 without any
Yeah.
addendums and supplemental stuff. That's just straight up the bare bones contracts, 27 pages. I remember it was 44 pages was what was necessary for proper seller disclosures and proper agency disclosures and inspection disclosures. And then, depending on the brokerage you're with, they add on 10 more other disclosures that they have decided are better than or supplemental to the California contract, for instance, right? Oregon, we're still good. We're about 11 pages here, which is pretty good. Any questions on this at all? Sonia, Kenny, anybody listening, you could chat and DM me if you have questions about this. You could argue it with me. It's okay. You'll win because I'm not willing to argue with you. But the reality is, this is my opinion on this from a coach's perspective.
So on the love letter thing, I actually had that situation come up last month here at a listing here in Galt. They sent me one. They sent me an email wanting me to forward it to my clients. It had a nice love letter. Oh, it's by my kid's school, and their friends live around the corner. And there's pictures of the kids and a video of them at my open house, actually in this email. So I'm looking at it and just like, man, this doesn't seem right. So I actually called the agent. I said, look, this is too personal. I think we're setting ourselves up for a fair housing violation, possibly on this, the way that it's made now. If you want to send me back something about how much they love the house, how much they appreciate the property, just basically just total facts about the house, then I will ask my clients if they want to see that. But as far as the way it's written right now, I cannot submit that.
I like it. So I'm gonna be devil's advocate. I happen to agree with you, but devil's advocate for this is you're now deciding for the seller without the seller's permission. And you might be right, right? You might be right in the fact that they go, this is super close to our church that we go to. And then you bring religion into it and you bring in, my grandmother was raised in the home, whatever it may be. And so I think it rests with the fiduciary responsibility with the seller. And in that particular case, Kenny, I would agree with you. I think the high road would be Mr. and Mrs. Seller. I got a email from a potential buyer. They're writing an offer on it. But to me, it's personal. To me, it's a personal request. To me, it's trying to get you emotionally bought into this transaction. And right now, we're dealing with financial, not motivational, through emotions. My inkling is that it should not be part of this conversation that we're having, but it's up to you. What would you like me to do to it or with it? If they go, it's no big deal, send it to me, then I would send it, right? Let them,
I actually did go there. I went there with
oh,
them.
good for you. Good for
I
you.
said, hey, by the
That's,
way, I have two emails regarding this property. I told them a story about how I didn't like how the first one was written, and I have the second one as far as like the facts about the house.
yeah.
Both my clients, husband and wife, both said, do not send it to me. I don't want to see it.
Interesting. And so then all you need to do is document that. Just please send me an email, Mr. and Mrs. Seller, saying we talked about the love letter, we talked about that, and you've decided not to, and again, you want to protect them too. So the language would be, we've understood that you've sent this through our agent Kenny. We've decided, husband and wife decided that we'd like to stick to the facts of the contractual side of this thing and not the emotional side. So we've instructed him not to provide it to us. Right. And then that goes in the file. Then you're 100%, never say 100%, especially in California, but you're 98% covered. Okay. That is a great example. And I'm glad you brought that up. That's a great example of how to handle it. You did a great job with that.
Thank you.
Too many times I see, like, I personally have experienced this where I got this just dripping, sappy, my daughter's in a wheelchair. This is a really perfect spot for them. She loves the swimming pool. It's going to help with her therapy. I'm making this up, but you can imagine it was a very emotional plea. And I told the agent, I said that, this is really not relevant to the house. I'm happy to introduce you to them. I'm happy to have all these conversations, but we need to stick to contractual right now. And she threatened to, sue me and take me to the board and ethical and all these things because I'm not providing everything to my client. And of course, I was on the other side having the conversations, but the agents are fighting for their lives. Their agents are fighting for their clients. The agents are doing all the things. I personally have just never been a fan of love letters. It's like, I get 12 offers and I have this one that's got a sappy email with pictures of their dog. And I personally have never really bought into that emotionally. It's like, I'm sorry, we're just dealing with the facts here, please. And like Bruce Willis, just the facts, ma'am. I love it. Sonia, questions or anything from you as we wrap up?
Yeah, I had a question for Kenny on that one. What had the sellers elected in the contract? Had they said you were or were not to present the letters?
Are you talking about the addendum in the contract that talks
No,
about,
there's an actual line item in the contract now where it's the same as opting in or opting out of having a lockbox or a sign. They have to say whether or not they will receive letters.
yeah, but that's fairly new too. That wasn't in
Right.
there just even a couple of years ago.
Oh
You
no,
know,
I
you know
mean,
what, Sonia? Is that on the car form?
yeah, it's on the car form and it is a relatively new item.
Okay, so I'm gonna look at that because I've been using the I know this is for all agents of all brokerages, but I've been using the EXP listing agreement on the float
Oh,
forms, and I actually just did one of those. I don't think I saw that on there.
huh. Yeah, that would be a good question because I think that removes, I think the idea is it removes some of the liability from us and from our broker because the sellers are making a decision right there in the contract as to whether you
Yep,
are
I,
or
I I agree with that. It's just like it's the same thing. I used to always have to write in my contracts, the offer will be submitted, whether it's verbal, written, or email communicated to my seller, because we got so many offers. I couldn't put them all into the computer and try and convey all those to the seller. So I'd call the seller and say, we got 4 offers. I'm gonna go over the highlights, and then I'll provide you anything that you want from them, right? But I had to present them verbally in many cases. We have to have that in writing, saying the seller's requesting us to communicate all offers, whether they be in writing, verbal, or email or text or whatever, right? If you have that in writing, then you don't have to provide written proof to your buyer that you submitted this particular offer. It's still good advice, still good um, procedure, but that's something that we had to do a lot, especially in the short sale and foreclosure days.
mm.
Yeah,
Cool.
it's actually not on that sky slope form. I just checked it out, so we'll look at the car one.
Yeah, so Sonia, thank you for that. Maybe you could send us that particular line item and let's break that down a little bit on a future thing.
Sure. How do I send it?
You could just email it to me or whatever you want to do.
Okay.
If you have it in front of you,
I
you could.
don't.
Okay. Yeah, no problem. I was going to include it in the recording, but it's all good. We'll get that. But again, that's a California car form, right? So California's put out something that they feel is the best thing to protect the consumer,
Right.
right? Brokers might be against it, and they have the right to be. Brokers may align with it or might go against it. Very cool. Well, thank you, everybody. I appreciate you being here. Kenny, Sonia, the usual suspects. We appreciate you. Tell the others, tell your friends. I'm doing this every week now. And then every time I say that, I'm out for like the next 2 weeks, but I'm usually here. I
Thank
appreciate
you,
it.
Randy.
All
All
right.
right,
You
thank you,
guys have a
Randy.
great day. Thank you so
Yep.
much. Bye for now.